button up, put on your seatbelts, get ready for some estate and tax planning magic. No, but truly, this really is, we joke, but you're probably going to get far more out of this than you will out of any TV show you watch, any movie you watch, any documentary. Frankly, this stuff could be far higher stakes for you. So that's why we're here. The topic of our presentation tonight, what now? Protecting your assets post-election. We have a little more visibility as to what happened in the last election, although we don't have complete clarity, but there are some high stakes changes in law that you need to understand, and we're here to educate you about what you do need to understand. So make myself a little clearer. I'm Mark Gilfix. I'm a partner here at Gilfix and the Poll Associates. My co-presenter here is Michael Gilfix. We'll give you, for those of you who don't know us, we'll give you a little more background about who we are and where we came from in a moment. But think of us as your guides for the next 60 minutes, again, to take you through these very high stakes issues. Understanding these issues can make the difference of hundreds of thousands or even millions of dollars for your family's future. There are so many incredible things that you can do to protect your family. And regardless, just understanding what's going on, there's a value in that. So we're here to empower you with knowledge and with an idea of what you can do for your family in these crazy times. So on that note, I'm going to get back to our slides here. And as we get started, I want you to take a moment just to think about why you joined us here tonight. We have a large audience, so clearly there's a lot on people's mind, but what got you to spend some time with us? And we greatly appreciate the time that you're spending with us. But what's on your mind? Are you worried about your finances? Are you worried about your family's future? Are you worried about the implications of the election? Are you worried about the world and COVID and everything? Or do you just feel overwhelmed as a response to all of that? I think we can all relate. And we can't help you with everything, but we can help you on the legal planning side of this, which can extend in so many areas of your life. We're here to help. We're here to deliver solutions. We've been doing this for a long time. Our firm's been around for over 38 years, and our track record speaks for itself. We work with thousands of families in the Bay Area, and we try to be ahead of the game. We try to develop solutions as soon as we see problems, and we're here to help guide you through those. And as I alluded to, the next 60 minutes that we're going to spend together could change your family's future. It's hard to wrap your head around all these issues, and I know it can be a pain to talk to lawyers or tax experts or to deal with this stuff. But there is such incredible value that can be unlocked. And we want you to think bigger than just the near term. We're bigger than just the pain in the butt of following these steps, and think bigger. Think about what you can achieve for your own future, for your children's future, for your grandchildren's future, if you have them. It is amazing what we can achieve when we work together and when we know how to navigate these challenging paths. That's why we're here tonight. The topics we're going to cover: why your living trust must be reviewed, or if you don't have a living trust, why it's so important to set one up. But if you have one, it's not good enough just to have one sitting on the shelf. You got to take a fresh look at it. We see all kinds of issues with existing living trusts. We're going to talk about the secret to protecting assets from divorces, lawsuits, and estate taxes for your children and grandchildren. We're going to talk about the implications of the election and Prop 19. It has some potentially devastating property tax implications for some families, but there are solutions. But there's a deadline for acting. You got to act before February 15th, 2021. We're going to go over that. We're going to talk about the 40% estate tax, why you might think it doesn't affect you, but we're going to tell you why it might affect you and why you at least need to be aware of it and what you can do if you do face issues. And all this goes back to how to protect your home and your hard-earned assets. That's what we're here for. And again, we're not going to be able to really take questions as we power through this, but we're going to try to get to as many questions as we can at the end. So feel free to submit questions through the Q&A function in Zoom, and we already have quite a few good ones. So we're going to try to get through these as we push forward, especially at the end of this talk. But we might answer some of these questions as we go. So the cornerstone of a lot of this, and why these issues are so poignant for people, especially in the Bay Area, but really throughout California, it goes to the family home. So Mike, why don't you talk about that?
Sure. Put everything on the slide, please. Okay. All right. So when we think about the size of our estate, we have to understand and accept that our homes are extremely valuable. Look where we live. I mean, reality is reality. Our homes are worth millions of dollars, whether we like it or not. And one of the reasons we think it's so important to stress this is that you might think that, oh, gee, I have a small estate, or I don't have one over a certain level. Well, think about your home and how the value has grown so dramatically over the last 5-10 years. Every time I think the house value can't go up anymore, it does. I mean, it is relentless. So we have to think in terms of the future. What is your estate going to be like in 5 years, 10 years, 12 years? Will that create estate tax exposure? And for so many of us, it's going to do exactly that. So again, you don't do a stagnant microscopic look at the value of your estate. Look at your real property, and we're going to really focus in a couple of times in a couple of different contexts on Prop 19 and its impact on our homes, and frankly, the ability of your kids and grandkids to retain ownership of your home. You might think it's a no-brainer. It's been relatively easy because the property tax breaks, gone. So again, we'll go through that, and we'll certainly talk about solutions.
Absolutely. And we want to extend a warm welcome to our existing clients and to people who know us already. It's always a pleasure to reconnect with you. And I'm sure there's some new people here who don't know us. So we're just going to take just a moment to introduce ourselves. And I think it's important to know where we came from. And I think that informs how we work. So I want to introduce my co-presenter, Michael Gilfix. I've known Michael for over 40 years. Because, as is probably obvious, he's my dad. But Mike is from a small town in northern Michigan, East Tawas, Michigan. I have the weather for East Tawas on my phone. It's always freezing cold for like 8 months a year. Gorgeous the other 4 months, though. He came out to the Bay Area to attend Stanford, both as an undergrad, and he went to the Stanford Law School, graduated in 1973. And I think what's really important to understand about Mike's history is that he didn't go to law school to join a big firm. He didn't go to make a bunch of money. He went to law school because he wanted to change the world. And when he graduated from law school, he did just that. He looked for underserved communities that needed legal help. He identified 2 older Americans and Americans with disabilities. He went out and he created America's very first free legal aid program for the elderly. SALA, Senior Adults Legal Existence, still exists today in Santa Clara County. But he didn't just create that. He went around the country and proselytized. He trained other attorneys. He raised money. He testified in front of Congress. He created a movement. He created the field of elder law. How do we know this? Because he owned the trademark for the term elder law when it was really coined. He ended up donating it to one of the many organizations that he started. He helped to serve hundreds of older Americans directly and thousands indirectly through the organizations he started, and really helped to create some of the legal protections that exist for older Americans today. Similar work in the disability space. In 1976, he started the Disability Law Center, one of the first free legal aid programs for Americans with disabilities. Special needs planning is a big part of our practice as well. So he's been a national leader for decades. In the early 80s, he left running in nonprofits to start Gilfix and Lepole Associates because he had a growing family. Francis Lepole, our tax guru, joined in the early 80s. My mom, Myra Gerson Gilfix, was part of the founding. But through the time that he's built the firm, he's remained a leader. And I think that's important to remember as well. He trains other attorneys. He speaks at national conferences. He's written countless books. We're going to talk about some of the books we've written, the articles that he's written on his own. He's been featured in the national media, the radio. So he knows what he's talking about. And it's a pleasure and a privilege for me to be able to present with him here today and to learn from him because he's really my mentor in the legal world. Well, he's my dad. He's my mentor in many ways. But as a lawyer, it's been incredible what I've learned from him. So he's the guy that trains other attorneys. I think that's the important thing. So you're getting to hear it directly from him here tonight. So with no further ado, let me introduce Michael Gilfix.
Thank you, Mark. As I start to introduce Mark, I think the important thing is, what does it really mean to you? We know our stuff, we've been around a very long time. We're very successful, but the real issue is what's the impact on you? And again, I make that part of the introduction for Mark because very significantly, Mark is the next generation. And if you think about this, when we're doing our planning, it's not for us. I mean, it is, but it's for our family. And Mark brings that second generation perspective, which has really dramatically affected the work that we do. It pays dividends for our client community. So with that little bit now, Mark also went to Stanford, graduated in 2001, had a very successful career with one of the top international management consulting firms in the nation. He advised some of the Fortune 500 companies, the Department of Defense, learned an awful lot about how how business works at the macro level. How does tax affect organizations? And it's directly relevant to the work that we do here. He went to law school in Southern California while working full-time as a management consultant. When he did that, he graduated at the top of his class. He was his graduation speaker. Since he graduated, Mark has emerged as a real leader. He's won a number of awards. And, again, what I think I got to come back to is how valuable his perspective is. It's been shared on a number of radio shows that he's been on, television, but he brings it to our office every day, and he brings it to you in the work that we do. So, if you're in my generation older, think about your kids and grandkids. And, Mark's representing that. If you're of Mark's generation, I think it's great you got me, because I'm going to be giving that older generation. So multi-generational planning is at the core of what we do. We think that's what it's all about.
Yeah. And that's a big deal. It's a lot of the planning steps we're talking about. You have to involve the next generation. This is not really optional. It doesn't work if you can't communicate between generations, or it works. It's a lot more difficult to do. And we know that it's not the fit for every family. We get that. But whenever possible, that's our presumptive approach. And just about our firm, we've been around a long time. And I think critically, we've been right here in Palo Alto. We serve clients throughout the state. So if you're watching this from anywhere from Wairika to San Diego, really anywhere in between, we can work with you, especially with Zoom. That's opened up everything. And our goal is to provide you with extraordinary value and to be a thought partner and advisor over time. It's not just about creating one set of documents. It's about helping you to think big picture. And that's really, really focused. It's not just us. I think that's important too. We have a whole team of attorneys. Francis LaPole is our tax genius, one of the top tax attorneys in the country, top left. Bottom right, Renee Conrad and Nick Klingenberg, both very experienced estate planners. We all work as a team. We have litigators on our team as well, Stephen Vernon, Cecilia Fusich. So we have a whole team, and we're here. We work as a team. We don't work in silos. So no matter who you're working with at our firm, if there's an issue, we all solve it together. So let's go into some mysteries. And we use mysteries just to show you some of the issues that we're going to explore. I think it's a little more fun to do it this way. Let's talk about a tale of supercharging a plan. We're going to solve these mysteries as we go. Larry and Wyatt, both of them received $2 million, or their fathers leave $2 million, both for Larry, and Wyatt's father does the same thing. They both got $2 million left to them. Both of them during their lives, think of them as basically living the same lives. Both of them endure a divorce. Both of them are sued after they're in a car accident. When Larry passes away, of that $2 million left to him, all of it's gone. None of it is there for his kids, and obviously nothing for his grandkids. Wyatt, same exact life, same exact issues. When he passes away, there's $6 million there. When that goes to his kids. When his grandkids pass away, there's 18 million that goes to the grandkids. A difference of $0, 2 million going to zero, or 2 million going to $18 million for future generations. What's the mystery? What was different about Larry and Wyatt's situation? We're going to uncover that.
Now we're going to do another mystery that focuses on the family home, which is much of the focus for the evening tonight. Okay, we have three individuals here. We got Tom, we got Jill, and we got Amos, old friends. Tom, again, we have roughly similar values as we look at these three examples. Okay, Tom, $3 million residence, that's the market value. The assessed value, $300,000. So his taxes are only about $3,000, maybe a little bit more than that per year. At his passing, his daughter inherits the house, and she just says, I'm going to keep it as a rental. Okay. We're looking to the future now. Tom passes away in 2022 after Prop 19. Property taxes go from about $3,000 up to about $30,000 a year. That's a dramatic, what, 1,000% increase. Jill, identical circumstances. The difference here is Jill, when she passes away, her daughter decides to live in the house. So there is going to be a bit of a break there. But the property taxes are still going to go up dramatically to maybe $20,000 a year, $3,000 to $20,000. Now, Amos, identical circumstances. He also passes away in 2022. Daughter takes ownership. With Amos, property taxes remain at $3,000 per year. So how can that be? What's the mystery? Now for this one, because we think this is so important, we're gonna give you the answer right now. And the other one, we're gonna come back to it. Okay, the difference here is Tom, he just left it to his daughter. Full reassessment. That's the deal under Prop 19. Prop 58, eviscerated, gone. It said that if you leave your residence to your kid or kids, property taxes don't go up. That's a dramatic change in Prop 19 that, I'll admit it, I didn't realize when I was reading the voter guides, and certainly when I heard the ads, that didn't even mention this change. Not a single ad mentioned this change. Okay, Jill lets her daughter live in it. So there's $1 million worth of assessed value protection, but still dramatic increase in property value, in property taxes. Amos, now the radical difference here, the reason we have a mystery and the way we solved it is before Prop 19 goes into effect, Amos took appropriate planning steps and he captured the lower property tax level for his child. He had to act before the new law goes into effect. The savings, this is not exaggerating, this is simple math, saving over $500,000 and as much as $1 million over his daughter's lifetime. Because again, we got 3,000 versus 30,000, and just do them, and that's going to increase every year. So it's a dramatic difference. We're going to come back, put a little more meat on the bones about Prop 19, but drink this in, it's dramatic.
Yeah.
Okay. Now we'll take a quick look at the 4 basic documents that are just absolutely fundamental that everybody should have in place. Number 1, revocable trust. And we've said it before, we'll say it again, you got to keep it up to date. It is not stagnant. You have to give it attention. You have to modify it and evolve it with the times as you change and as the law changes. Durable power of attorney, not a simple form, not check the box. You have to have an advanced healthcare directive that's up to date, that reflects your wishes, not, again, a simple document. Now, fundamentally, there's 3 basics that everybody should have regardless of the size of your estate. We strongly believe that there's a 4th necessary document because the benefits of a family protection trust are just off the charts. They're that good that you should do it. Presumptively, you should set that trust up for your kids. A little bit later, Mark is going to explain why, but keep these in mind. These are the 4 necessary basic documents that you need to have in place.
And this is to cover everything from healthcare decision-making to managing your day-to-day bills. It really covers the whole spectrum, but then a whole lot more. And we get a question, and all the time, there's a lot of confusion out there about wills versus trusts. And a lot of people think, well, a will is fine. Why do I need a trust? And the terms are very confusing, and we see people mix them up a lot of the time. There's a big difference. You don't just want a will. A will is not enough if you have any assets, and especially if you have kids. So why is a will so bad? Well, if you have a will and everything goes, it's properly set up and everything goes according to plan, it still is exposed to what we call probate after you pass away. That means that everything has to go through the California court system. Now, if you love dealing with the IRS or the DMV, you're going to love leaving your family with the fun process of probate. It means that your entire estate has to be overseen by California courts. It's not distributed to your beneficiaries or heirs until a judge oversees it and says that it's okay. The process can take up to 2 or 3 years, sometimes longer. The fees are 2 to 3 times the cost of just administering a trust. They're very, very expensive. And it's totally public. So anybody can see everything about your estate. So often you'll see a celebrity pass away. I remember James Gandolfini from The Sopranos. He passed away at unfortunately an early age. And there were all these tabloid stories about everything he had and all the money that was going to his kids and all these other people. And you're thinking, like, why was that public? Why do we get to see that? It's because his assets were exposed to probate. So they were made totally public. And so everybody got to see it. So not a good thing. And if you happen to have property in another state, like if my dad got that dream cabin in East Tawas, Michigan, and he just had a will, not only would there be a probate in California, there'd be a probate in Michigan as well, a separate one for property in that state. So it's just a pain. Additionally, a will doesn't help you while you're alive. You need an executor who can't help you until you're gone. So they can't help you at all. So they can help your estate. They have no power until you've passed away. A trust, on the other hand, is a way of privatizing your estate. A living trust doesn't change your taxes. It's just a way to make sure that you can empower people to step in for you when you need it. So that can mean while you're alive, you name a successor trustee who can step in and manage your major assets without your family having to go to court. That's also the person who oversees the process after you're gone, but you don't have to go through the court system. There needs to be administration, but it's private. It's done between you and like your attorney and advisors. Not exposed to this nightmarish process. The fee is much lower for dealing with a trust administration than a probate. And it helps you while you're alive. You get to name backup trustees who can step in. And there's so much more we can build into a trust than we can to a will. So this is a living trust we're talking about, by the way. That's a trust you would create for yourself. There are a whole lot of different types of trusts you can create, but a living trust is what we all need. It's a revocable living trust is another term for it. So Mike, why don't you talk about why just because you have a revocable living trust doesn't mean you're in necessarily great shape?
Yeah, for a married couple, if we prepared your trust, or if any competent attorney prepared your trust more than maybe 4 or 5 years ago, it's just pretty much automatic that you would have been given what is called an AB trust. Not going to go through what that means right now, but the point is this, that because of developments in the law, you might not need that structure anymore. We can still maximize estate tax protection, but there's a different approach that we can now take that might make you more comfortable. Roughly 40–50% of our clients use the alternative approach, even if they have a somewhat larger estate. So again, the need is to take a look at what you have right now, make you aware of the pros and cons of the alternatives, and then make the right decision. The structure of your trust has a huge impact on how much estate tax you capture. It's got to be drafted appropriately for you. So, the off-the-shelf, download it from the internet. I mean, you're watching us, this. You just don't do that. I mean, this controls your lives. It protects and holds your assets. It's incredibly important. And it's just important to be up to date. And notwithstanding whatever legal developments or tax developments we talk about in these webinars, we've learned over the years that most people who contact us after seeing one, they just want to have their trust reviewed. Makes sense. You don't have to have a burning issue about Prop 19 to come and see us, and just make sure that you're up to date and that everything is drafted appropriately for you. A necessity.
Yeah, so that's a living trust that you create for yourself. Now, what can you do for the next generation? Family protection trust. They're generically known as dynasty trusts. Now, why does Bernie Sanders want to get rid of these? And he's not the only politician who's on record saying that dynasty trusts should not be okay. Why would that be? And I think as we explore it, you'll see why. And this is not a political statement. He's just public saying that. And just to be clear, these are very politically charged times. We are not saying any of these laws are good or bad. We're here to report them, and we're here to report the tools that are available to deal with them in your context. So we're the messengers. We're here to arm you with knowledge, and what you do with that is up to you. What are family protection trusts, and why are they controversial amongst some politicians? Well, there's a lot in the media about this. If you Google the term dynasty trust, that's the generic type of trust these are. The ones that our firm Gilfix and Nepal does are family protection trusts. That's our version of these. Now, why would you create family protection trusts? And just as a bigger picture, let's say you're married, you and your spouse would have your own living trust. These come in later. So if you have 2 or 3 kids, let's say you have 3 kids, instead of leaving assets to your 3 kids, you would create a family protection trust for each of your 3 kids. Family protection trust 1, 2, and 3, separate from your living trust. And you would say, when I pass away, assets aren't going to my kids. They're going to the family protection trust I created for my kids. Now, why would you do that? 3 big reasons. Divorce rates are anywhere from 40 to 50%, who knows, depends on the statistics you see, but they're far too common. If your child inherits money and commingles it at all with their significant other, if they get divorced, it could be lost. A big chunk of what you leave them could be lost. If you create a family protection trust, the assets you leave your child are separate and will not be lost in a divorce settlement. They're not commingled. 2, if your child is sued, anything that they inherit directly in their name, fair game in a lawsuit. If assets are in a family protection trust, there's a barrier. It's hard for someone to break the barrier of that trust, so there's a level of protection for the money that you left to your child. Car accidents lead to lawsuits, business deals lead to lawsuits. We live in a litigious society. It kind of is what it is. This is a way to protect or provide a level of protection against that. When your child passes away, everything that they inherit from you, plus everything that they earn during their lives, is part of their taxable estate. Depending on what estate tax laws are in the future, and we're talking 10, 20, 30, 40 years in the future when we're talking about your kids, we don't know what those laws will be. It's just so far out. But it's very possible it could be very strict. So a good 30, 40, 50% of what you left your child could be lost in estate taxes if they inherit it directly before it goes to your grandkids. If it's in a family protection trust, virtually all of it can pass from your kids to your grandkids, plus future growth in value, estate tax free. It's not part of their taxable estate. That alone can save hundreds of thousands or millions of dollars for grandkids. And you might be thinking, well, these are all nice, but I don't like the idea of saddling my child with a trust. I don't want them to have to answer to some big trustee or some bank or whatever. Your child can be his or her own trustee if you think they're responsible. Or you can put age limits to say up until they're 30 or 35, someone else is in charge of it, but once they're a certain age, they can take over for themselves. So these are incredible tools that can give your children the ability to manage and benefit from what you leave them virtually as if it's their own, but with all these incredible protections against divorce, against lawsuits, and against future estate taxes. And these trusts last for over 100 years. So they really last for your children's lives, grandchildren or future grandchildren's lives, and even part of your great-grandchildren's lives. So it's kind of like creating a prenuptial agreement for your kids and grandkids and even great-grandkids. It's hard to wrap your head around this, I know. And the numbers get very big very fast when you're looking across generations. Hard to wrap your head around, but they're so extraordinary. And this last point on the slide, not just for the ultra wealthy, high net worth families and dynastic families, the DuPont family, the Walton family, all that, they've been doing planning like this for a long time. They've had teams of attorneys telling them what to do, and they've done it. The masses, in the Bay Area, it's a relative term, but most people don't think about this. They don't do it. They think that's only for the super wealthy, and that's just not true. It is just as powerful for someone who has just a house in the Bay Area as it is for someone who has many millions. The protections are still relevant for everybody, and we want you to know that these exist. You don't have to be ultra wealthy for these to be powerful for you. We want everybody to be able to, if they want, put these incredible protections in for their kids and grandkids and great-grandkids. So we want to arm you with information and empower you. Now let's circle back to the trivia piece, or the mystery that we talked about earlier with Larry and Wyatt. So remember, Larry and Wyatt, both $2 million was left for their benefit. Their dads left them $2 million each. Both of them had, let's think of them having the same jobs, the same lives. They endured the same divorce, the same lawsuit. Larry, nothing was left when he passed away for his kids. Why? Because he inherited directly. When he got divorced, 50% of it was lost. When he got sued, he lost the other 50% of the $2 million inheritance. Nothing from his dad was left for his kids and grandkids. Wyatt, on the other hand, $6 million when he passed away, that grew to $18 million when his kids passed away, when it went to his grandkids. Why? Because his father created a family protection trust. Wyatt didn't inherit it directly. A family protection trust for his benefit did. So when he got divorced, the money wasn't lost. It stayed in his side of the family. When he got sued, the person suing him said, oh crap, there's a trust here. I don't want to mess with that. They settled for pennies on the dollar. He didn't lose a bunch of money there. Went to his kids, worth $6 million because it grew during his life. He invested it decently. His kids inherited it through the trust, invested it pretty well, maybe used it to buy a house. It grew over their lifetimes to $18 million, untouched by estate taxes when it goes to the grandkids. So all this to say, you might be starting out with $2 million. I know that's a big number, but that's a house in the Bay Area. How that can go to $18 million in just 2 generations if you have the right plan into place versus 0 if you don't. So family protection trust, that's why we consider them to be the 4th set of documents that every family really needs.
And before I mention this, I feel the need to reinforce that point. I've long felt that, ironically, perhaps, if you have a smaller estate, only 1 million, 2 million, around here, 500,000, I would say it's all the more important that the assets you leave your kids are protected. It's easier to lose a smaller amount and have nothing for the grandkids, for example. If you have millions, one way or another, there's going to be something left. So, this is a middle class issue, not just the upper class. It just bears so much emphasis. This protects assets for your family and your lineage. Can't overemphasize. Okay, let's go to the special needs issue. We talk about these dynasty trusts. They're appropriate for most kids. If you happen to have a child with a disability, in other words, a child who can't work and make a living, if they're disabled in the context of government benefits, they're going to qualify for quite a number of government programs. One will provide income, another will provide health insurance. There's some that provide housing, services. It goes on and on. So this is not the focus of tonight, but we never ever want to talk about trust planning without mentioning special needs trusts, which are the type of trust that you use if you have a child who's qualifying for those benefits. Any amount of money can be left for a child in one of these trusts, and it does not disturb eligibility for government benefits. It provides a lifelong safety net for that child. So you have your cake and eat it too for your kids. They're going to qualify for all the government benefits, and you're going to have money and perhaps a house set aside in the special needs trust to take care of your child for his or her entire lifetime. And by the way, on the screen is the brand new, I mean, we only got the book published about 2 weeks ago. This is the 3rd edition of our special needs trust book. It is entirely up to date, talks about the ABLE Act, other developments. So, for our clients, you may already have it, or you'll get one. For others, let us know if you'd like to get one. We'll come back to our other books a little bit later. So, special needs trusts. Okay. We talked earlier about the power of attorney, and let's put a little meat on those bones. That we see so many powers of attorney that are the 2-page summary. California legislation actually creates what's called the statutory power of attorney. And many attorneys and many individuals just copy it out of the book, out of the code, and that's it. And it's fine, frankly, for most purposes, but not all. If a power of attorney is going to be used because you or your parent becomes incapacitated, that document has to give explicit language if proactive steps are going to be taken to avoid tax or to protect the house if Medi-Cal is needed. It has to have language that is sophisticated and appropriate. And the document needs to be up to date. So, this is not a big expense. It's a modest expense, but it should be reviewed. If you've done it years ago, got to make sure it has the tools, the language in that document that will let your family take care of you when needed.
Yeah, I see we're getting some great questions and some people raising hands. So again, we're going to try to get to questions at the end. So feel free to submit them in the Q&A function, and we'll try to get to as many as we can as we get to the end of this. And now let's switch gears just a little bit to a subject we talked about a little bit before, with the California election results. And before the election, there were really 2 initiatives that we were kind of tracking to see, if they passed, it had big implications for many of our clients. Prop 15 lost. We're not going to spend any time on that. As we talked about, Prop 19 passed, and that on a state level is a really big deal. We gave an example already. Let's revisit this because this is something that is timely, as in you have about 2.5, 3 months to act before it's going to get a lot harder to deal with this. So what does this mean? As Mike said, until this law passed, we had Prop 58, which passed in the mid-'80s. I don't know the exact year. That basically said mom and dad can pass their house to their kids as long as the parent-child transfer, no matter whether the kids lived in the primary residence or not, no matter how much the fair market value was, kids got to inherit mom and dad's very low Prop 13 property tax rate. So if mom and dad's house was worth $10 million, but they bought it in the 60s or 50s, and their property taxes were based on a value of $100,000, paying $1,000 a year in taxes, the kids would get to pay $1,000 a year in taxes for the house, whether they lived there or not. And mom and dad could pass up to $1 million in other property in assessed value, Prop 13 assessed value, that could go to kids at a very low property tax rate, whether the kids live there or not. So primary residence plus a bunch of rental property could go to the kids with no change. That's gone. So Prop 19 ended that. It replaced it. So now a home, if kids don't move into mom and dad's house, as we've talked about in that illustration before, if you leave your house to your kids and none of your kids claim it as their primary residence after you're gone or after you transfer it to them, there will be a full reassessment of property taxes. That can be tens of thousands of dollars a year in California, depending on when the parents bought the house. And there is no protection for other properties. So if you have a rental, a duplex, a fourplex, whatever, rental house, no, you don't have that $1 million in assessed value protection. So all of that would get reassessed. And if your kids do live in the house, only the first $1 million in increased value is protected. So let's say it's a $10 million house that you bought for $100,000 decades ago. If kids inherit it and live in it, only the first $1 million in the gain in value is protected. There'd be a $9 million reassessment in property taxes. In that case, it'd go to $90,000 a year in taxes. So it's a huge change. From no change in property taxes to maybe property taxes going up 10,000% in some cases, or at least a few 100%. So it's a big, big deal. And it's important to understand it. And Mike, do you want to go through? Actually, I can just go through this. We kind of talked about. Let's go to the
next. I think we've covered it. Let's go to the next example on the next slide.
Yeah, and just to be clear, even if so, the key thing that where the biggest misunderstanding was that I think if you read the marketing materials and you looked at even the voter guide, frankly, was confusing about this. It seemed as though as long as the kids live in mom and dad's house, there's no reassessment in property taxes, and that's just wrong. There's some protection, but property taxes for many, 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 many families, even if the kids live there, will go up substantially, even if the kids live in mom and dad's house. So Mike, why don't you go through this?
Yeah, let's look at the, we've already talked about Tom and Jill and Amos and what happened with them, and Mark reiterated. And, you know, when we reiterate and revisit, it's on purpose. I mean, there's some points that are just so important that we just have to convey them effectively to you. So let's take a second then and look at a slightly different example very quickly. Bill and Andre. Now, here we're not talking about the residence. We're talking about an investment property, a rental property, as so many of you may have. Okay, Bill's fourplex, assessed very low, 200,000, market value, 2 million. Here we go. He passes away in 2022. That's going to be a rough year. Property taxes go from 2,000 up to 20,000 plus per year. Dramatic increase, right? And you think about the impact on net income. I mean, that's just a pure drag. Okay. Now, Andre, same values, same property, let's just say. He passes away in 2022, but property taxes remain the same. And why? Well, obviously, Andre acted. There are steps that we can take. We've developed at least one and perhaps two alternative approaches that can be used. You have to do before February 15 to retain the property taxes and still, frankly, capture some other tax benefits. We believe we're going to be very successful with this. And it's vital. I mean, if you have either of these profiles and you want to make sure that your home is not going to have to be, that it's going to be retained, if that is your goal, you absolutely have to explore these options with us and think about what steps you can take. Now, we always coordinate this planning with the Family Protection Trust. So if we're going to put together a structure so that your home can effectively be conveyed to two kids, 50-50, let's just say, you're not going to have the house ultimately go directly to the kids 50-50, right? As we implement the Prop 19 planning, let's call it that, when ultimately the property is distributed to your kids, it doesn't go to them, it goes to their family protection trusts. So we're capturing the property tax protection, we're actually getting an estate tax protection, other protections as well, and then it's going to be in their family protection trust so they can enjoy those assets, grow those assets for the benefit of your perfect grandkids. Multi-generational thinking here. Awesome stuff.
Just a side note, my parents just had their first grandchild. Wasn't mine, it was my sister's. But my younger sister, Jamie, just had a grandson named Miles. He was born just over a month ago. So now that grandchild protection is a lot more meaningful to my own family, right, Dad? So
yeah, kind of a wonderful thing. Well, you know, most of you can relate. Huh? It's
been a tough year in many ways, but also some great blessings.
Well, we need some optimism, right? And some reasons to be positive looking forward.
Yeah. And just to this point, there is a February 15th deadline. We are starting to get inundated with interest about this. If you have questions, if you think this is going to affect you, you need to set a planning meeting with us so we can go over it in detail. These are high stakes issue and there is a hard deadline. If we get you in and see you in the next couple of weeks, 2 to 3 weeks, we will have time, if you choose to move forward, to develop these solutions. If you wait till February 5th or February 10th or whatever last minute, we probably won't have time to do it because the solutions we're developing will take some time. But we can absolutely do them before the deadline for those of you who want to take action. So that's a spoiler alert. Set a meeting with us right away if this is top of mind, because we are getting a lot of demand about this. Now, let's transition to another issue that's been on a lot of people's minds. I had some clients this morning who, this was the focus of our meeting, was concerns about the future of estate taxes and taxes at the federal level. Prop 19 is a state issue. What's happening at the federal level? Well, we have a new president, Joe Biden, Democratic Party, obviously. The Congress remained, or the House, I should say, remained Democrat controlled. Now the Senate, we still don't even know. There's a runoff. There's 2 runoffs in Georgia after the beginning of the year. So we won't actually know who controls the Senate until January. And if Democrats take that, then we'll have one party in control of all 3 houses. And that's when tax laws change. If Republicans hold on to the Senate, then we probably have gridlock. So that means probably not that much changes for at least a few years. So what does the election mean? What does it not mean? Will tax laws change? Will trust law, the family protection trust laws change? At the end of the day, barring what happens in Georgia, we think we do have some certainty. We think it's very unlikely, unless Democrats take both of the seats in the Georgia Senate runoff, that estate tax laws won't change. We'll go into what those laws are. We think it's very likely they'll stay exactly as they are. Joe Biden, he's put some proposals out, but a president can't shape tax law. He needs both houses of Congress to go along with it, to frankly draft the laws. The president can help guide it. So you may read articles about what Joe Biden's proposed in the past. Those are almost irrelevant until we know what happens with the Senate. And even if Democrats control all three houses, what presidents propose, Obama had proposals for years that never went into action, even when Democrats controlled all three houses. So the key is, in the near term, we don't see major changes for the estate tax law, at least in the next couple of years. We do think there are a lot of steps we can take with some good certainty right away. Now, we'll keep a close eye on Georgia, but at the end of the day, we don't have alarm bells going off about what you see here, the death tax. That's a question that a lot of people have on their minds. Like, will the death tax change? It's actually the estate tax. And if you look closely at this, it's the Grim Reaper. I'm not sure if he's delivering a tax bill or getting a tax bill. I guess you'd have to think of him delivering a death tax bill for it to make sense. Although I don't know why there'd be spider webs in the mailbox if he's delivering it to you. Your mailbox would be, anyway. The point is, death and taxes are two things that are certain in life. What's happening with the estate tax, also known as the death tax? That's the area that our firm focuses on the most. So Mike, why don't you talk about what laws are today and why you might have to be worried about that?
Sure. So the estate tax is a punishing tax if you happen to be exposed to it. If you have too much, if you're blessed with having too much, it's a 40% tax. So if you have $1 million over the allowable limit, $400,000 of that $1 million would go to the government. Okay, the current level of protection is extremely high. It's the highest it has ever been, except one year when by odd circumstances, we had no estate tax. It was a remarkable year, quite a few years ago, probably never to rear its head again. The current level of protection, almost $12 million. Think of it as $12 million for discussion's sake. For a couple, over 23, almost $24 million can be passed along without exposure to the 40% estate tax. Now, if there is an estate tax, the tax is off the top. You know, how big is the estate? If it's over the limit for a single person or a couple, a check is written from the estate and then everything goes to whomever you want it to go to. Okay. When your kids or others inherit money from you, that is not a taxable event. The receipt of an inheritance, like the receipt of a gift, not a taxable event. So after that tax is paid, if any, everything that goes to the kids remains with them, not exposed to more tax. Now, in California, and this is an important point because, California does tend to increase a few taxes on occasion. Our counties do, our cities do. So, it's unending. I mean, let's face it. Okay. So California has no estate tax. It was eliminated by a voter initiative many years ago. Could it come back? Absolutely. I mean, there's been proposals in the California Assembly and probably the Senate, although I haven't seen those in the past, that would impose a state inheritance tax again. There's quite a number of states that have it, so this wouldn't be a crazy aberration, but it's something that, we don't see anything in the hopper right now. Believe me, we watch it carefully. Not a factor. So it's really exclusively a focus on federal estate tax legislation. And obviously for us, how do we take it into account and help you plan to avoid that tax? And do you have a taxable estate? What's the size of your estate? Our consistent experience is that when we sat down with somebody and we just say, hey, what's your estimate? What do you think the estate is? Invariably, unless the person is an engineer, for you engineers out there, except for the engineers, the estimate comes in about 20% too low, invariably. So it is more than you think. It's more than you think. It's your home. It's all real property. It's the gross value of your IRA and 401k. If you have paid on or own a life insurance policy, the death benefit is also part of your taxable estate. What if you own a nice little villa in Italy or a little place anywhere else in the world? That's included in your taxable estate as well, obviously in other states as well. And also, as we said at the very beginning, the value of your assets, it grows. So you don't take a static look at what you have. If you're a married couple and you have like 8 or 9 million, I would say that come 2026, when it goes down to about 12 for a couple, you have to think about this. Again, be proactive and look to the future so that we plan appropriately.
Yeah, and you might be thinking, well, okay, yeah, my estate may be bigger than I think, but you're not adding any numbers up to put me at 24 million. I mean, like, that's a great problem to have. Even in Silicon Valley, that's pretty rare. But maybe you own a home and you're thinking, okay, well, I have a house and maybe I have some savings, but still, these are huge numbers. Why don't I have to worry about this? Well, in 2026 or sooner, Dad, you kind of spoiled the lead there, but there's going to be a change.
Sorry.
Winter is coming. For you Game of Thrones fans, you might know what that means. Maybe you're not a Game of Thrones fan. Winter is coming doesn't sound very good. What do we mean by that? Well, let's say there is gridlock at the federal level and nothing changes. You cannot sit back and just not worry about this, because if nothing changes at the federal level, the current law is set to sunset, meaning it will end. It is set to end on January 1st, 2026. At that time, the exemption will be cut in half. It will be sliced by 50%, the amount you can pass tax-free. So even if nothing changes, if you're single and you own a home, think about this. This is 6 years in the future. Let's presume the economy gets back to growing, and even home values have been going up even during the pandemic, which is pretty nuts. But let's say the economy starts to roar again in Silicon Valley. The value of your home could go up by 50, 60, 70%, right as the estate tax exemption is going to plummet. Just owning a home in the Bay Area could mean you have estate tax exposure. And a lot could change before then. We mentioned the Georgia runoff. If Democrats win both of those, we maybe could see a change before then. And there's going to be elections every 2 years, as you may or may not recall. You may want to forget how stressful the last election was, no matter what side you were on. But there are elections every 2 years. So we could see major changes every 2 to 4 years. Our point is, you got to keep a very close watch on this, because let's say you do have some estate tax exposure. There are all sorts of totally accepted by the IRS techniques we can use to dramatically reduce any exposure, to potentially eliminate it. We've saved families millions and millions of dollars using strategies that have been approved by courts, approved by the IRS. This is not smoke and mirrors. This is not cutting corners. There are a lot of techniques you can use to reduce estate tax exposure, but this is where multi-generational planning and thinking bigger comes into play. And Mike, why don't you just give some examples of the many tools that you can use to reduce estate tax exposure that we've used for our clients?
Okay, so let's just have a sampling here. Now, no effort. I couldn't overemphasize. No effort is made here to talk about all the planning tools and techniques that you can use to reduce the size of your taxable estate while still protecting the estate. Okay, we've talked about a living trust, and that matters. I mean, if it's properly structured for a couple, we're going to capture the maximum level of estate tax protection for each spouse. So we're effectively doubling the level of protection. If your home is very valuable, I mean, like 5, 8, 10 million or more, and you can just be in the right location and you have that challenge. Okay, there's an irrevocable trust into which your house can go, where we can capture enormous discounts to reduce the size of your taxable estate. Family limited partnerships, LLCs, allow for something called discounting as we structure a plan for you, your kids, and your grandkids, where everybody is a part of the planning. Charitable giving, you may be charitably inclined, you may have eleemosynary motivations, you may not, but you like some of the tax advantages that you capture with something called the charitable remainder trust. There's charitable lead trust, there's charitable annuity trust, it goes on and on with the options. If you remember, we said if you own a life insurance policy, the death benefit is part of your taxable estate. If instead your life insurance policy is in an irrevocable life insurance trust, the death benefit, 1 million, 2 million, 3 million, is not part of your taxable estate. That alone could save $1 million. So it's available. We've stressed family protection trust. Frankly, they don't protect your estate from estate tax, right? They protect the estates of your kids from estate tax. So this is just a sampling. There are many tools, many arrows in the quiver that we can use. At the bottom, we make reference to our book, Beat Estate Tax Forever. Frankly, we sold out. We have no more of the second edition books. I had to give up the last book I had on my bookshelf to send to a client, but we finished the third edition, and it's going to be published and available I hope in just about 2 weeks. So we're going to make it available then. In it, we identify these and more planning options, and we give examples. It's very readable, very understandable. Bottom line, though, if you have a larger estate, your issue is estate tax avoidance, not so much Prop 19. And it's not irrelevant, but this issue overwhelms Prop 19 issues if you have that 40% estate tax exposure.
Yeah, and just again, we're talking about big numbers. I get it. Many of you here might be saying, I get $5 million house, $6 million, that's great, but I don't have that. You know, I'm not in that boat myself. One day I hope to have a house that could maybe give me a taxable estate. But for those of us who don't have these large estates, do I need to think about these? Yes, you do. Because if you understand them and if you keep an eye on them, if you're educated, you know what to look for. You know steps you can take in the near term to protect your family. And as we talked about, there's stuff you can do for your kids and grandkids that are relevant, whether or not you're even close to these numbers. And all the taxes we're talking, there's also capital gains taxes, which are a big issue. So if you don't have estate tax exposure, we got to think about capital gains tax exposure for the next generation, how you can pass assets to eliminate different types of taxes. So it all comes together. And this is why you have to think holistically about this. It's not, there is no one size fits all approach. It just can't really be done because every situation is different. And that's why we like what we do. We get to know the people that we worked with. We love to work across generations whenever possible to bring the kids into the discussion because that can be really powerful. But we believe that coordinating across generations is critical. We've written articles about this in legal journals. We've given talks at national legal conferences. We think that all lawyers should look at these issues this way. I think there's a lot of lawyers out there who still kind of do the traditional, you know, I work with mom and dad, we put the documents in the drawer and you don't open them until there's an emergency. We believe that whenever possible, families should work together. We live that and breathe it. You know, my dad and I, we've been working together for over 7 years now, and you know, we get annoyed at each other at times, but we know the big picture is far better when we're working together for so many reasons than it would be to do our separate thing. And that's how we like to work with families. We've helped thousands of families with this. We've saved families millions of dollars. You don't have to be high net worth to save lots of money by creating the right planning steps. And again, just take a step back, just imagine what we can achieve together for you, for your children, for your grandchildren, if you're empowered with all of this. You know, we work so hard to save, we work so hard to invest the right way. We scratch and we claw for an extra 2% stock market return a year. You know, you're crushing. If you can outperform the market by 1 or 2% a year, you're Warren Buffett, you know, and we do so much, but then we often drop the ball when it matters the most, when we're talking about where all this is going to go. And a few mistakes towards the end of your life or even during your life can cost every good decision you made, every good investment you made, every decision you made to save money and not traveling in business class, but taking the coach seats because it saved a bunch of money. All those decisions, every time you did that, all wiped away by a few bad moves where you don't take the steps you can. We write the books on these subjects, as Mike alluded to. We co-authored a book called Facing the Reality of Long-Term Care. So you have long-term care issues. How do you think about that? How do you protect assets? Special needs planning, beat estate tax forever. So we literally write the books on this. We think about this a lot. And coming from a family of estate planning attorneys, we go on like camping trips and we talk about these issues. Not all the time, but we're thinking about solutions all the time. It's what we do. So we threw a lot at you. We're going to get to questions in a moment, but what can you do now to protect your family? The first piece of advice we can give you is attention is a powerful thing. Right now, your attention is on this. The moment you step away from this, your attention is going to get robbed. It's going to go in 15 different directions. There are multi-billion-dollar technology companies who have teams devoted to creating distractions, to get you to look down at your phone, to look at your Facebook, whatever. Take action while this is top of mind. Maybe that's just making a list for yourself, but we would welcome the opportunity to work with you. We would say if these things are top of mind right now, especially the Prop 19, you need to set a meeting with us. We can look at your existing documents. We can talk about your situation. We can talk about the trade-offs involved in different solutions and develop a plan that fits your unique needs. It's not a one-size-fits-all approach. That doesn't work. We would just develop one that works for you. And then over time, if you join our client community or if you're in it, we're here as a thought partner for you. We are here to help you stay on top of these issues. This is not a one-time and you're done type of thing. There are really powerful tools we can put into place that hopefully should be good for a long time, like family protection trusts. But as laws change, as your situation changes, we need updates. And so, you know, why would you work with us? Hopefully we showed why, just through this presentation, how we think about things, how we communicate. It's important that whoever you work with, that you enjoy talking to them. You know, if you feel scared of asking questions to your advisor, they're probably not the right advisor for you. So, you know, why us? I think, Mike, if you want to add anything here, you know, we've been doing this a long time and we focus on this exclusively. We integrate tax planning with trust planning, special needs planning, and our goal is to deliver extraordinary value. You know, it's not just to get you in the door, create a trust or two and get you out. It's to help you save your assets over time and to deliver incredible return on investment. We have something called the Peace of Mind program for clients who work with us. If you want to stay in regular touch with us over time, we have programs to do that. So if you would like to set a meeting with me, and I think most of you frankly should, if you have these Prop 19 issues, if you have trust questions, tax questions, you need to set a meeting. We have a February 15th hard deadline for this new law. Set a meeting with us right away. If you want to do it, our calendars are starting to fill up literally through the end of the year, but we do have availability. We have a good sized team, and we want the chance to serve you. If you would like to set a meeting with us, you can email Ashley. Her email is at the bottom of the screen. You can call our office, 650-493-8070 tomorrow. You can leave a message tonight. You can go to our website, gilfix.com, to find all this information. And just to make it easier, if you would like us to reach out to you, we're going to answer some questions in a second. Feel free to enter your name and your contact information in the Q&A function. And no one else can see it, then only us. And we will take down your information. We'll reach out to you this week to set an appointment with you. I would say, again, if you have Prop 19 questions, especially, you need to set a meeting right away. Mike, do you want to just briefly talk about how we do meetings and how we structure that?
Sure, happy to do that. So when we have a consultation, we do charge hourly for the meetings. Many attorneys do free meetings. We don't. We haven't done. It's not our style. We like to get right into it and give you value. You know, we're not there to try to convince you of something that's not appropriate. So we do charge. We get no complaints about that. You know, we deliver real value. So we do charge the hourly rate of the attorney with whom you meet. It might be 1 hour, might be 2 hours. If you do documents, we do flat fees, and there's never a surprise. We always put into writing what our fees would be. And two quick examples. If you're a single person and we're going to do your trust and there's no crazy circumstances, the fee is typically under $2,000, under $2,000. If we're doing one of these dynasty trusts, which lasts for like 100 years, our fee for one is typically $3,100. And we don't triple it for three. You know, we do much less. Our fees are mainstream, in my view, low, very comfortable, best investment you're ever going to make. So do give us a call. And, you know, and obviously we enjoy what we do, which is one of the main reasons it's a good thing for us.
Exactly.
So let's get to some questions, huh? And,
I'm going to put ourselves back on the screen. So hello, everyone, again, to see our full suites. We have so many good questions. And again, the impact that can be made when you take these steps is amazing. We've gotten some nice notes from some current clients just saying hello. So hello, everyone out there. We have so many questions here. Okay. So,
I have one. I have one. Okay. In fact, this came up a couple of times. Some existing clients, if you already have a family protection trust, do you have to redo that? What if you're going to be doing this Prop 19 planning? You know, if we create one of those trusts for you, it's probably fine. We're probably not going to create a new one. We're going to use it. It's going to not be recreated. It's going to be integrated into the planning. So, you know, that was a great step. You did the right thing, and it's going to pay dividends because we can be much more efficient in taking care of any new developments and steps that we take.
Yeah, and we had a question with Prop 19 in effect, kind of to our example. How can a house held in a trust avoid property tax reassessment if a child plans on living it as if a child's going to live in it and something happens after 22? Well, if this happens after 22 and no steps are taken, there would be a property tax reassessment. We are working on a few solutions right now that can prevent that in a tax advantageous way. It's not as simple as it might seem, but we are working on that. And the laws evolve. We're going to get some guidance from the state in the next couple of weeks too that will help us hone it even more. So we're working on solutions that will prevent that reassessment. And a question, can property title held in a trust be changed through a trust, or does the title need to be changed via a new deed? So anything for property title needs to be done via a deed. But so if you create a new trust to transfer title of a home to a new trust, we create a deed that has to be recorded with the county to transfer it to that new trust. Let's see. So we have so many questions here. How does Prop 13 relate to Prop 13 regarding the step up in basis that previously existed when someone passed away and a residence is inherited? So Prop 13 actually has nothing to do with the step up in basis. Step up in basis just happens if something's in your taxable estate. Anything you want to add there, Mike? That's something people need to be aware of.
Well, I think that's been a worry because there was some talk from the Biden campaign that they wanted to get rid of the stepped up basis and make that when you died, if you had a gap between what you paid for something and its value, there was talk of making that a taxable event, which it's never been before. So, you know, we don't think that's going to happen. I'll just tell you that. So when you pass away, assets in your estate, stepped up basis. If your kids then sell it, there should be no capital gains tax, regardless of Prop 19.
Right, and that's where the solutions to Prop 19 get complex, because we have to balance these issues: the step up in basis, the property tax issue. You don't want to give up one for the other. Let's see, so many questions. Yeah, a lot of questions about Prop 19. You know, and we're going to learn more from the state. What if only one child lives in the home and others don't? We believe that as long as that child's living there, probably would get the protections. We're going to learn more, though, how the state's going to enforce this. Mike, you have one?
Yeah, no. Here's another one that I think is really core, and I forgot to mention this. Forgive me. Okay, the question is, are there any exceptions if the house is going to go to a special needs child?
Mm-hmm.
No.
Nope.
So one of our biggest worries here is for the special needs client, the family, where it's critically important to protect and preserve the house and leave it for the special needs daughter. In the past, you know, property taxes would have been the same. Now they're going to go up so much that maybe another $200,000, $300,000, $500,000 is going to have to go into that special needs trust so that the house doesn't have to be sold. So it could be devastating for special needs families in particular, and we're gonna follow up on this vigorously.
Yeah, and we have a lot of questions about Prop 19. If you're an existing client, what do we do? Come in and we can talk about it, because it's not clear. It won't make sense for everybody to act, but a lot of people will. It's so there's ways that we can deal with that, and you know, we need to meet with you to learn about your situation. There's a lot of trade-offs with different solutions. So and the question, does the Prop 19 get rid of the step up in basis? No, Prop 19 has nothing to do with the step up in basis. That's federal law. Prop 19 is property taxes. That's state law. So again, we got to weigh all these factors, and there's solutions we're developing that deal with both.
I got to say, Amy has a comment here, says, so confusing. Yeah, you know, we try so hard to keep it as succinct as we possibly can and compartmentalize Prop 19 over here and estate taxes over here and the stepped up basis over here. You know, they're separate, but they're just so interconnected. And thank you, Amy, for the comment that we are not confusing. It is.
We try.
Yeah.
And Mark has a good question that if the state's still figuring this out, how can a meeting with us be useful? Well, one, we got to get the process started ASAP. And two, we don't think that the state's guidance is going to affect the main solutions we're working on right now. Key is, if you don't get the process started right away, we have no chance. You know, if you wait till the last minute till we have perfect information, which even then we won't have perfect information. We can't 100% guarantee anything. We can do the very best we can. And taking action is a heck of a lot better than not. But, you know, we'd say the sooner you act, the better. Set a meeting with us if you have questions, or one of our colleagues. We all work together on this. It's not like if you meet with Mike, you get one solution. If you meet with Mark, no, we work together. Nick Klingenberg is awesome on our team. Renee Conrad, Francis LaPole. Excellent. Question, does the Family Protection Trust protect cousins and nieces if I don't have children? Absolutely. You can create a family protection trust for anyone in the next generation. So they do need to be the younger generation, typically. There can be benefits for the same, but yes, you can create a family protection trust for nieces, nephews. We have many clients do that. And we're going to take just one or two more questions. We're already past our deadline, but we really appreciate this. And we have some people who want to, again, if you want us to reach out to you, we put your information in. We have a few people who put your name and your number in. Please put that in and we will contact you if you'd like. We have questions about availability. So we do have time available in December still. Mr. LaPole is mostly booked up. We have some available. We can get you in if you set a meeting right away.
I'll just say we're going to be working long and hard. I mean, that's the way it is.
Yeah.
So we're gonna work really hard to accommodate, and our job for you.
Yeah, and Dan DeCamp wrote a nice note, so good to hear from you, Dan.
Hey.
So a lot of, we have a lot of questions about Prop 19 and things like that we can't get into more details than what we have. There's only so much we know, frankly, at this point. But we do have some solutions we're working on. So I think we got to wrap it up. We're way past the time here, and it's late on a Monday. But I appreciate everyone being here. I'm going to try to make sure we get everyone's contact information who's reached out. But again, regardless, you can reach out to our office directly, 650-493-8070. Gilfix.com is the easy way to find us too. But we got a lot of good email addresses and numbers and things like that. We will reach out to you guys. But again, for those of you, I see like Art, you asked to see about setting up a meeting, reach out to us. If you didn't put your information here, that's fine. Call our office. We'll get back to you as soon as we can. We have a lot of demand right now, but we will get to everybody who sets meetings right away. So again, I'm copying down everyone's requests here. So thank you so much. You can also write to Ashley or email, lots of ways to contact us, but we hope you got a lot out of this. If you enjoyed it too, share, let your friends know. We're going to make some of our webinars available online. Share it online, feel free to review us, to say this was useful or whatever, to say anything. We always appreciate that. Bottom line, we thank you for spending time with us. And again, we hope you got a lot out of it. We hope you guys and your family stay healthy, right? It's a crazy time. Stay healthy, stay vibrant, and we're here as a resource for you guys. So
good
thank
night
you
to
guys
all.
again, and have a wonderful, wonderful night. Take care.